Indigenous knowledge is a term that a broad term that covers traditional know-how, traditional skills, traditional techniques in in doing a particular activity, and it applies to different fields. It also covers traditional cultural expressions like your folk songs, your folk dance, your traditional attires, clothing, even shoes, traditional artworks, and yes, and it is the important thing about it, the important feature about it is that it is passed, it's a knowledge that is passed down from generation to generation. It also includes traditional knowledge in relation to the use of genetic resources, the use of biodiversity. For instance, the use of udia as appetite suppressants by the San people, the use of rooibos as beverage by the San people. These are types of or examples that I can give of indigenous knowledge. The rights holders of indigenous knowledge systems are indigenous communities, indigenous peoples, and these indigenous people spread across different parts of Africa. An example I can give would be the San and Khoi people that you find in South Africa, in Botswana, in Namibia, and different parts of Southern Africa. These are the rights holders of indigenous knowledge systems. It's not indigenous knowledge. The rights in indigenous knowledge systems are not owned by a particular person. They are communally owned by indigenous peoples or indigenous communities. The laws governing indigenous knowledge and indigenous knowledge systems are complicated. They are in layers, and they are some of them are already being implemented, like the National Biodiversity Act and its Access and Benefit Sharing Regulation, while others like the Indigenous Knowledge Systems Act of 2019 and the Intellectual Property Amendment Act of 2013 are not being implemented. Indigenous knowledge systems can also find protection under conventional intellectual property laws like the Copyright Act, the Trademarks Act, the Patent Act, the Designs Act. If, and I use the word if, the indigenous knowledge systems meet the criteria, for protection under those acts. But in practice, however, given the nature of indigenous knowledge systems, there's always a challenge of fitting indigenous knowledge systems within the protection of those acts that I've mentioned. Yes, there are laws in South Africa to protect indigenous knowledge systems, but the indigenous knowledge systems would have to fit into the criteria for the protection of those laws. For communities to protect their indigenous knowledge systems, they first need to organize, and by that I mean they need to come together, create a body, that represents them, with which through which they would negotiate or they can engage with, third parties that seek to use their indigenous knowledge systems. After that, following that, indigenous communities would need to develop protocols that will govern the use of their indigenous knowledge systems by third parties, and such protocols will indicate or define conditions that will govern access by such persons and benefit sharing from the economic exploitation of their indigenous knowledge systems. Such protocol would, obviously have to also address questions of informed consent, how third parties can gain consent from the indigenous communities for the use of their works. That is not enough. Indigenous communities would then still have to collaborate with the relevant government agencies, and yeah, these three approaches or these three steps can help indigenous communities in protecting their indigenous knowledge systems. Okay, to seek legal advice for the protection of their indigenous knowledge systems, indigenous communities would have to consult, obviously, lawyers that are experts in that in the field. I would say that lawyers who are practicing in the field of intellectual property law. They would also need to alternatively seek guidance from the relevant government agencies, obviously within the field of intellectual property law, or those that are concerned with issues that concern indigenous communities and their rights.